thank you for joining Thompson Hine's weekly coffee chat series. My name is Josh Hinderleiter. I'm an associate in Thompson Hine's investment management practice group. This is the 7th, if you can believe it, webinar already in our weekly coffee chat series. And these concise and practical discussions focus on a variety of developments that impact the financial services industry. Today, we're continuing our discussion on the SEC's new marketing rule. And as some not breaking news, we wanted to give all of our viewers an update that the rule has now been published in the Federal Registrar and will, per the terms of the rule and the publication, become effective 18 months after May 4th, 2021, which by my calculations is an effective date of November 4th, 2022. So keep that in mind as we're going through and discussing some of these items today in terms of what's changing, that the clock is now ticking towards that effective date. Let me introduce our panelists for today. First is Jackie Hummel, a partner and managing director at Hardin Compliance Consulting, LLC. She is a securities attorney and consultant with extensive experience as an in-house attorney, working with investment advisors, broker-dealers, and private fund companies. Before joining Hardin 10 years ago, Jackie was the Chief Compliance Officer for PNC Capital Advisors and PNC Realty Investors at PNC Financial Services Group. She also served as in-house counsel for National City Corporation's investment advisor and broker-dealer affiliates and acted as CCO for Allegiant Asset Management Company. Jackie served many years as an in-house counsel for Mass Mutual Financial Group, a diversified financial services organization where she advised the investment management division. Also joining us is my colleague, Craig Foster. Craig is a partner in Thompson Hine's investment management group. Craig regularly assists registered investment advisors with all aspects of their operations, including formation, registration, licensing, disclosure, privacy, client contracts, employment agreements, compliance programs, and website and advertising review. In addition, Craig frequently helps advisors navigate and respond to regulatory examinations and conduct annual compliance reviews. As a quick bit of housekeeping for any of our viewers today, if you have questions during the presentation or comments, we encourage you to join the discussion, make it as interactive as you'd like by using our Q&A box on your control panel. We'll address your comments as we move through the presentation and try to leave some time at the end for a Q&A session as well. If for whatever reason we don't get to all of the questions today, we'll follow up accordingly after the presentation. Okay, so as I mentioned in the introduction, today's focus is on the SEC's new marketing rule and how these regulations deal with testimonials, endorsements, and solicitation activity. To start, Jackie, could you give us the background on how testimonials and third-party ratings are treated under the current regulatory scheme and what has changed under the new rule?
Sure, Josh. First, we're going to just start with talking about testimonials. And as you probably all know, you couldn't use any testimonials. It was not allowed under the old rule. It was considered inherently misleading and fraudulent by the SEC. Rankings could be used with lots and lots of very specific disclosure from no action letters. Client lists could be used as long as the clients were not selected using performance. And also you had to include a disclaimer stating that it's not known whether the listed clients approve or disapprove of the advisor or the services provided. And you had to disclose the selection criteria. Social media reviews were also allowed, but they had to be independent. You couldn't do any editing or sorting, and you couldn't pay for them. There could be no compensation involved. So moving on to the new one, finally, now testimonials, those are the approval from clients, and endorsements, which are from non-clients, are allowed, and you can pay for them, but they are going to be treated like solicitations under this rule. Now, Craig's going to talk about the paid endorsements and testimonials. I'm going to talk about the ones that might be unpaid. We're just going to talk a little bit about how the new rule treats rankings. They're defined as a rating or ranking provided by a non-related person that is, quote, in the business of rating or ranking. It requires disclosure of the date of the rating and the period covered, who created it, and any compensation paid by the advisor for getting or using the rating. So, and you're also, a new requirement is due diligence is required by the advisor to make sure that the solicitor, the survey that is soliciting these opinions is unbiased. So you're required to kind of at least look at the questions to make sure that they're not like specifically leading or, offering to give you, $50 card if you select a particular advisor, etc. And under this new rule and the new treatment of this is kind of a different definition than as we've been used to. And the examples of things that are now considered testimonials and or endorsements that would include a quote, refer a friend program, actions by lead generation firms or advisor referral networks. That's kind of like if you go onto a particular website and it says, oh, we'll match you with an investment advisor. Those are now considered testimonials or endorsements. And also a blogger's website review of an advisor's services. Now, what is not a referral or solicitation can include getting client lists or selling investor lists. If you get those kinds of things from various providers, they're not considered testimonials or endorsements. Okay, so when we're talking about unpaid tests, so just so I can be clear, so if you have, I'm sorry, I just got a little out of whack here. Anyway, so the new requirements for these unpaid testimonials and endorsements require one, clear and prominent disclosure. So I'm going to say that again, clear and prominent disclosure about whether the testimonial provided by the client or investor, first, was it an actual client or is it just which would make it a testimonial, or is an endorsement, which would be a non-client. You have to make that clear and prominent right up front in the notice itself. You have to say whether there was any cash or non-cash compensation received, and whether the promoter, I'm just going to use that term as kind of a combination of a testimonial and endorsement person providing either one, the promoter has any material conflicts of interest with the advisor. And that has to be at least as prominent as the ad. So when you have something like, just to try to, try to think of what this might look like, and I'm sure the marketing people are going to hate it and everybody's going to hate it, because it's going to require you to say something like, let's just say Tiger Woods recommends ABC advisors because it helped him, they helped me retire early so I can enjoy time with my grandkids. Right under that, you probably have to say Woods receives, let's assume he receives a reduced advisory fee for this, for his testimonial. So you have to be very clear what his potential conflict of interest is. You don't have to specify the conflict right in that particular disclosure. You could put it at the bottom of the page, but I'm not really sure how that's going to look. Like, you're going to say like, so-and-so provided this, testimonial, and, this so-and-so has a material conflict of interest. See below for description of conflict. I'm not sure what that's going to look like. It sounds kind of strange right now. So the other thing, what I was just talking about is the material conflicts of interest don't have to be described up in that clear and prominent piece. They can be described elsewhere. And also, this is also going to be an additional pain in the butt because of the fact that you have to have advisor oversight and compliance. So you have to have a reasonable belief that any testimonial or endorsement complies with the rule. Now, it's easy enough when you're controlling that testimonial or endorsement, like on your website. But if you are using, like one of these advisor referral websites, you have to make sure that they're complying as well. So you have to look into that. There are some exemptions where you don't have to provide all this, the disclosure. That includes an affiliated person of the advisor. So that's like, you know, if you have IARs, independent contractors that are kind of under your control, that would be covered. They don't have to provide the disclosure, but you still have to oversee, the advisors all have to oversee their compliance with the rule. Broker dealers who might provide an endorsement to a retail customer, as long as it's subject to, as long as it's a recommendation subject to regulation BI, that's, you don't have to have disclosure on that, but it's still subject to oversight and a written agreement. And if a broker dealer provides a testimonial or endorsement to an investor who is not a retail customer, because presumably those people can look out for themselves. So I think that takes us to paid recommendations. Craig, we discussed the regulatory scheme governing solicitors and how that has changed under the new rule.
Happy to do that. So right now, if you're using a third party or any solicitor to recommend your firm and you're paying them, you probably know what you have to do. It's all covered by a separate rule right now, Rule 2064-3. And unless your solicitor is an affiliate or your solicitor is only recommending you for impersonal advisory services, you need basically three things. One is an agreement, a written agreement with your solicitor that has specified provisions. Two, you need to make sure your solicitor gives your firm's disclosure brochure, your Form ADV, to the prospect, and a separate disclosure document that clearly says, hey, I'm being paid to make this recommendation, and here's what the terms of that payment looks like. And the third thing is you actually need to get that signed by the client and returned before the client can be engaged by the advisor. The current rule only covers cash payments, and there's some limitations on who your solicitors can be. They can't be subject to any of the specified disqualification provisions for certain legal events in their past. And finally, right now, interestingly, private fund advisors are not covered by the rule. There was a no action letter called Mayor Brown that specifically said this rule is about recommending advisory services, not investment products. And so right now, private fund advisors are not included. But a lot of that's going to change. So under the new rule, 2064-3 goes away entirely, and all the requirements for using solicitors are going to be found under Rule 2064-1, this new marketing rule. As Jackie said, there's a redefinition here of two words, testimonial and endorsement. So just to review those really quickly, a testimonial is a statement by a current client or an investor about their experience, soliciting the advisor, referring them to the advisor. An endorsement is a statement from anybody else, so someone who's not a current client or investor. It allows advisors to compensate someone for using a testimonial, or for making a testimonial or an endorsement, as long as the advisor discloses themselves or believes the person giving the testimonial endorsement discloses their status as a client or a non-client, whether it was paid and the terms of that payment, and as Jackie mentioned before, material conflicts of interest. There also has to be a written agreement with that person paid to give a testimonial or endorsement, unless the compensation is de minimis. And what does de minimis mean? The rule gives a threshold of $1,000 that's aggregated over a 12-month period. So anything less than that, you won't need a written agreement. And interestingly, if you're only making de minimis payment, you don't have to worry about the disqualification provisions. The advisor also has to oversee compliance with the rule, and other than for de minimis payments, folks who would be subject to the disqualification provisions still can act as promoters. Finally, this rule specifically kind of does a 180 on the Mayor Brown position and subjects private fund advisors to the rule. So I told you the current requirements and the new requirements, but just to be clear, I want to kind of go through very carefully what is the same and what will change. So under the new rule, you're still going to need to disclose the arrangement. Obviously, the SEC is concerned about recommendations and testimonials that are paid, and folks not understanding that the speaker is being paid. You're still going to need to have a written agreement when you're using a third-party person. You still need to oversee compliance with the rule. You need to worry about kind of the legal and disciplinary history of the persons that you're engaging, except again, if you're doing de minimis compensation. And kind of outside the rule, there's some other things that aren't changing either. For many folks who are engaged to be solicitors, they might be subject to professional conduct rules, maybe for accountants or lawyers. Those outside of the new marketing rule, they may still prohibit an individual to serve as a solicitor, so you still need to worry about those. In addition, state blue sky laws still may require your solicitor to be licensed as an IA rep, so those are some things you still need to keep on your radar. But the big differences are these. The disclosure content is different. You need now to think about what are the conflicts of interest, the status of the speaker as a client or a non-client. A big deal is that now non-cash compensation counts. So it's not just cash, but also non-cash compensation. The SEC realizes that conflicts associated with giving folks gifts of entertainment or things like that still present the same kind of conflicts as cash compensation. One of the big kind of improvements, especially in the age of technology, you now no longer need to deliver your phone brochure or get a signed disclosure back from the prospect. And finally, as I said, the private fund advisors are now subject to the rule. So they're going to have to really think about if they're using third parties to get folks to invest in their funds, they're going to need to create new policies and procedures to cover themselves.
Great, and I just wanted to say that we've had a few questions come in, and so thank you for those. Right before we go to our Q&A, now that we've gone through what's changing in the regulatory scheme, Jackie, could you provide maybe a little more practical advice as what should advisors be thinking of? What changes to their compliance program might be needed? And Jackie, you might be muted.
Sorry about that.
No worries.
Yeah, anyway, now, I mean, you're basically going to have to revise your marketing and advertising review process to include the clear and prominent disclosures and other disclosures regarding the nature of the material conflicts of interest and compensation. You're also going to have to create policies and procedures to establish a reasonable basis that any testimonial or endorsement complies with the requirements of the rule. And so as you see, made the ever popular suggestion that you can ask your investors or clients that were referred by a promoter if that promoter complied with the rule. And they've suggested that before, and most firms are like, "Are you serious?" You also want to make sure that you have a process in place to review the advertisements that any promoter is using to promote your services. So if you're using like a Wise Advisor or a Smart Asset service, you want to make sure that they're complying with the requirements of the rule. And you probably want to do on the back end review any statements provided by promoters after the fact. You're also going to have policies and procedures to perform due diligence on ratings and rankings. You're going to have to ask to review the questionnaire or ask questions about the methodology of how those rankings were created. You want to make sure that the provider is, quote, in the business of providing rankings or ratings, and I have no idea what that means. You want to make sure that the questionnaire or survey makes it equally easy for a participant to provide a favorable or an unfavorable response. And you want to make sure that those survey questions are not designed to produce a predetermined result, meaning no leading questions. You're also going to have to go back in history and review your existing solicitation arrangements and revise them to comply with the new rule. There is no grandfathering provision. Make sure that if your firm ever starts a new program, such as a refer a friend program or any other kind of referral program that provides cash or cash compensation for client referrals, make sure that compliance is brought in to review those. And remember, as always, update your Form ADV Part 2A disclosures to discuss referral arrangements.
And now I'm muted. Very, very good advice, Jackie. And yeah, as we all know, this overhaul of the SEC's marketing regulatory scheme is decades in the making. So there are certainly going to be lots of potential things to consider and updates. But so as a general matter for our presentation today, that concludes the prepared presentation. And now I encourage you, we have a few questions in the queue, but if anyone else has questions, please submit those over. I'll go through now the questions that we have. I'll take these in order. So the first one that we had come in was, anyone can post a Google review of any business that has a Google listing. If a client mentions that they have been happy with our services under the new rule, is it permissible to ask them if they would consider posting their thoughts on Google reviews? Craig, Jackie, who do either of you have any thoughts on that question?
Yeah, I think you can ask for that. I think you're going to have to be careful about that, making sure you don't make any, if you do decide to make any promises with respect to, oh, we'll give you a break on your advisory fees or something like that, then you're going to have to go through all the requirements of the rule. But I think if you are not paying for that, I think the requirements are a little less. But I think it really kind of depends on how you make that request. I'm thinking if you just did it kind of in an offhand manner, that might be one thing. But if you basically, that was part of your standard operating procedure for every single client, then you might have to, be more concerned about oversight and compliance with the rule. I don't know. What do you think, Craig?
Yeah, I think that's exactly right. I think the first question is, are you giving any kind of compensation, whether it's cash or non-cash, because that will drive, whether you're falling into the new solicitor requirements or not. If you can structure it so that there's really no argument that you are giving compensation, then I think the other thing to think about is you want to remember conflicts of interest. And so if you now have an ongoing relationship with a number of clients, a handful of which have given you positive reviews and some that maybe haven't, you want to make sure that your account review process is such that you are monitoring to make sure that none of those clients, that all clients are continuing to be treated equitably, and that the reviews that you're getting are not tipping the scales in favor of one client or another as far as your service level.
Yeah. Our second question that came in is, will there be any types of disclosure necessary for an FMO to recommend an RIA to advisors they work with and are looking for a new RIA? Any types of disclosure that they might consider?
Can you repeat that question?
Yeah, absolutely. Will there be any types of disclosure necessary for an FMO to recommend an RIA to advisors that they work with and are looking for a new RIA?
Yeah, so I mean, this rule is really required more of getting clients for an RIA, not necessarily. I mean, this sounds more like a recruitment of advisors. So I'm not really sure that this new rule would apply, but I'm not sure I quite understand it.
I think I would answer similarly. This might be outside the scope of the current rule, but we can look into and follow up with the person who asked it.
Absolutely. Our next question is, if a consultant has your strategy on their best buy list or has rated your strategy, they are basically recommending your strategy. Are consultants deemed endorsers or are consultants deemed endorsers or testimonials?
I don't think that is the case. I think there's a specific section of the release. I know it's pretty long, but they did talk about this. If a consultant is basically reviewing various investment strategies for a client and recommends one based on their criteria, I don't think that's going to be considered an endorsement or a testimonial. If the advisor, provided information, but, just said, here's my data if you want to look at it, I don't think that's going to be considered an endorsement or a testimonial, as long as there's no money changing hands or referral fees. And this is based on the fact that the consultant does their own due diligence. I don't think that that's going to be considered an endorsement or testimonial.
Yeah, I think that's right. It kind of ties back to some of the stuff we talked about last week. You might remember that Brian talked about, how involved is the advisor in that third-party conclusion on how well your strategy is doing. I mean, as long as as Jackie said, that it's based on objective data and not getting the advisor involved more than that, and kind of writing the report or anything like that, I think you're in the clear.
Great. Our next question. If I heard correctly, there needs to be oversight of any ranking or rating. Does this apply to consultants to provide a buy rating or an alpha rating? What would this oversight look like?
Sorry, can you repeat that question?
Yeah. The question states, if I heard correctly, there needs to be oversight of any ranking or rating. Does this apply to consultants to provide a buy rating or an alpha rating? What would this oversight look like?
I guess it really depends on the context. I mean, again, if a consultant is doing their own due diligence and you haven't, I mean, one of the rule is looking at relationships between advisors and others that are going to, and using, that are going to be used in advertisements that might be, I mean, it's mostly aimed, I think, at retail clients so they can understand why recommendations are happening, and they understand that there's payment involved. If a consultant is providing a buy rating or an alpha rating based on their own due diligence, and you have an advisor has no relationship with that consultant, I don't think you would have any oversight responsibilities. What they're really talking about is if you are, if you want to have these, if you want to show all these different types of ratings or rankings, like, let's say Pension and Investments lists the 100 top investment advisors. Well, that you would need to go look at, like, well, how did they do that ranking, and what was the universe, and how did they select those? That's I think that's a little different than an independent consultant providing its own recommendations.
Great. So I think that concludes all of the questions that we had in our Q&A. And again, I encourage all of our viewers here today, if you have follow-up questions for either of our panelists, obviously, please feel free to reach out to us, and we would be happy to continue the discussion. We are right at about our time for today. And I just wanted to let everybody know that our next coffee chat will be hosted a week from today on Wednesday, March 17th, when our Thompson Hine colleague Mike Weibel will be joined by Les Abramovitz from Foreside to continue the discussion on the SEC's new marketing rule, and they'll highlight the structure of performance advertising, the use of hypothetical performance, and the use of interactive analysis tools. To register for future coffee chat discussions, visit the events page on the Thompson Hine website. And as a reminder, all of our coffee chat presentations will be hosted on the Thompson Hine YouTube channel. Just search for Thompson Hine in YouTube and subscribe, and you will get the updates on any of all our upcoming recorded coffee chat events. Thank you to all for your interest in attending today's program, and a special thank you to Jackie and Craig for sharing their insight. As a last bit of housekeeping, when this webinar ends, you'll be prompted to take a survey providing feedback. Please take this survey. The feedback that you provide is very important to us and helps us continue to tailor our programs to meet your needs. Thank you again to everyone for your attendance today, and to our panelists. We hope you have a great day. Thank you.